News headlines over the last few days would have you believe that Prince Harry is appealing the High Court ruling over the security provisions when he visits the UK. They would also have you believe that there'll be significant taxpayer backlash if he does so. But as usual, it's not quite that straightforward, but that's what I'll discuss in this video. So welcome back. If you're new to me, I am Daniel Shensmith, a barrister of England and Wales, and I'd be very grateful if you hit that subscribe button because about 60% of you that regularly watch don't do so. And that's the one thing I do ask of you. And just as a heads up, this video is in part supported by my partner for this channel, Incogni, but more about them a little bit later. So let's take a look at some of these headlines and why I suggest they are not giving you the full picture. Because if we look at one or two of these, they read Prince Harry to appeal after losing the battle over security arrangements. The next one is Prince Harry will appeal after losing the legal battle over taxpayer-funded police protection. And then Duke of Sussex to appeal again, the High Court ruling. Prince Harry highly unlikely to win High Court appeal, as he's warned over taxpayer backlash. So still from the Mirror, although leaning towards highly unlikely to win, still suggesting that the appeal will go ahead, which is not an absolute given. Allow me to explain. You see, in civil cases in England and Wales, there is no automatic right to appeal. Many people might not know that that's the case, but in fact, there are rules to appeal, and before you can just go headlong into an appeal, you first need permission, which is not altogether straightforward to obtain. Now, there are very few cases in which you don't need permission. For example, a committal order, that's where you're held in contempt, a refusal to grant habeas corpus, and so on. But otherwise, you do need permission. Now, you can either get that from the judge that made the original decision, which is in most cases unlikely, not always impossible, but in most cases unlikely, or from the appeal court to which you wish to challenge that decision. Now, there are two tests for appeal, the first appeal and the second appeal. The second, of course, being even more difficult than the first. That is, once you've had permission originally, appealed the decision, lost the appeal, and then you're going for a second appeal. That would be a second appeal. Now, you can initially seek permission to appeal from the judge that made the initial ruling, which, as you can imagine, once they've just made a ruling, they are not likely to say that there's a reasonable prospect of successfully appealing that decision, unless, of course, there's an obvious question of law or something else that comes up that might give a real prospect for which they might grant permission. So it's not impossible, but altogether unlikely that you'll get permission to appeal from the judge that made the original decision. You could then, of course, seek permission to appeal from the appeal court. The alternative argument is that there's some other compelling reason for which your appeal should be heard. But either way, as the wording in the rule suggests, this must be a compelling reason for the appeal to be heard, not just because a party doesn't like it. Now, if an application for permission to appeal is made within the county court, i.e. from one level of judge to another within the county court, or to the High Court, for example, from the county court to the High Court as the appellate court, then the decision is usually made on paper without an oral hearing. But then the appellant can opt for an oral hearing to renew the application for permission to appeal. But at that stage, there is still no permission to appeal, so the appeal itself is not live yet. And there's a separate section for applications for permission to appeal to the Court of Appeal, where the court will determine the application on paper without an oral hearing, unless the judge is of the opinion that the application cannot be fairly determined without an oral hearing, and then will direct that oral hearing to take place. But coming back to the Prince Harry case and the likely merits of success on this permission to appeal, they are, in my view, somewhat slim. Whilst the news reports would have you believe that the appeal is live and he is, quote, appealing the decision, which is not quite true. He might be seeking permission to appeal, but that isn't a given as yet. In order to successfully obtain permission to appeal, one would usually expect that there is some procedural error, an error of law, or some sort of fresh evidence that wasn't available with reasonable diligence the first time round, neither of which are likely given that this was a high-profile case in the High Court. It is extremely unlikely that there's going to be any procedural error of law, and it would be exceptionally difficult for any party to obtain permission to appeal simply on a finding of fact made by the judge at a hearing. And so all in all, it's my prediction that permission to appeal will be refused. But even if it isn't, it'll be my second prediction that the appeal itself would fail in any event. And I'm not the only one that thinks so. There are certain experts quoted in the news stories that seem to think the same, and our learned friend Alan Robertshaw over on Art of Law, yes I know it rhymes, linked in the description below, had the same views as me. You'll find his video linked below, but I also get a lot of questions about appeals and people challenging or seeking to challenge decisions that they don't like in court, even on occasion when I've agreed with them and respectfully disagreed with a learned judge as to the finding of fact that they've made. I'll give you one such story about that in just a moment, but first a word about my partner. Now, just as an aside, but staying on the topic of security and a proactive action that I would encourage you all to take to protect your personal identity. You see, about a month ago, there was a report of a data leak of one of the largest of its kind ever recorded, with over 26 billion, that's billion with a B, records being leaked via some kind of open storage solution. These records across LinkedIn, Twitter or X, Adobe, Canva, all sorts of platforms having their records leaked online and potentially falling into the hands of bad actors. Now, how this might affect you is that there are already marketing companies that sell on your data, and in combination with those records, they might be able to piece together just enough information to impersonate you. And it is for that reason that on this channel I partner with Incogni, which helps to protect your personal identity. You see, Incogni is a done-for-you service which, when you sign up, they will contact all of these data marketers and brokers and require them under existing legislation to remove your records from their databases. So however they've come across your records in the first instance, they will be required by law to delete those records immediately. Now, some people will say that they just don't delete them even when they are required to do so. But that being the case, if you were to be a victim of identity theft and you were to trace it back to one of these companies to whom you've made this legal request to remove your information, then you would have further recourse against the company. And you might recall a video I did a day or two ago where I received some scams to my mobile phone. Now, not many people, as you can imagine, have my mobile phone number, and yet I receive an increasing number of these scams, which is telling me that somebody is selling on my data, which is why I personally use Incogni, and I get weekly reports from the team at Incogni as to which companies have complied with my legal request to remove my data from their databases. You see, identity theft can have a devastating effect on people's lives. It is not simply somebody popping up online pretending to be you. One of the things that they do is go to loan companies or mobile phone companies and take out multiple contracts in your name because they have just enough information that they've pieced together to be able to pretend to be you. And by combining any information that's been leaked online with that they might have obtained legitimately from one of these data brokers, which quite literally sell you as a package and your information, they might then get enough information to pretend to be you. And you will then be left unraveling all of this mess, which might even mean going to court, fighting debt collection agencies, and even bailiffs. So the positive and proactive step that I encourage you all to take right now is to take advantage of my discount at the link in the description below, sign up for Incogni, and let them do all of the work for you. They will contact all of these data brokers and legally require that they remove your data from their databases. As I said, it is a done-for-you, set and forget service. You sign up and they do all of the work for you. Then you'll have the peace of mind that you are getting ahead of the curve of these marketing companies selling you on again and again, because eventually enough of your information might end up in the wrong hands and they can try to impersonate you. So sign up for Incogni, the link is in the description below, and thank you for allowing me the time to thank my partner for my channel. So as mentioned, here's an example of a judgment with which I respectfully disagreed, although there was also nothing we could do about it, because the only basis for appeal would be to challenge the finding of fact made by the judge. There was no error of law, there was no error of procedure, and there was no evidence that we obtained afterwards that we couldn't have, with reasonable diligence, have obtained the first time round. In fact, there was no evidence after the event, and so the only basis would be to challenge the finding of fact, which is just not going to work for permission to appeal in a case like this. So in order to anonymize the case sufficiently, I will just say that it was a consumer case over a large piece of stone, and it was one colour and on challenge was supposed to be another. That's the basis of the claim. Now, this case was brought on the basis that this piece of stone was advertised on the website, it was advertised in brochures, and even as a sample that you could physically hold in the hand to be of a particular style and colour. Only when it was delivered, the claimant was of the view that it was a very different colour. So on the one hand, the claimant's interpretation of the website, the brochure, and even the sample was that this stone was a particular shade of pink. Now, I'm not talking bright fluorescent pink, I'm talking about the sort of rock stony kind of pink. Whereas the one that was delivered and installed was more akin to silver in the claimant's view. The defence was that this was a natural stone and therefore subject to natural colour variations, and that the colour may vary, and this was so noted within the terms and conditions. Now, the deviation between the two colours, as perceived by the claimant in this case, was seen to be unfair and therefore a breach of contract. But the judge disagreed, making a finding of fact that the terms and conditions made it quite clear that the colour might vary somewhat, and therefore this was a natural variation in the colour of the stone permitted by the terms and conditions, and was therefore not a breach of contract, and so the claimant should accept it. And so in this case, the judge dismissed the claim and ruled instead for the supplier. Now, this is one such case, in my view, that a lot of people might disagree with, because the colour of an item and whether it's acceptable might be a very subjective opinion. But the judge making a finding of fact that the terms and conditions permitted a variation in colour, and that this variation in colour was within those terms and conditions, meant that the only real ground of appeal would be to challenge the finding of fact made by the judge, which is just not going to work in a case like this. So the takeaway from all of this is not just that permission to appeal is very often difficult to get, but that a judgment is very often just a finding of fact made by the judge on the day, given their particular views and interpretation of the facts. So it can be very difficult, and makes it all the more important that you do seek formal legal advice before embarking on these legal journeys. But I hope you found that useful. Please do like the video and subscribe if you did, and as always, thank you for watching.